Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources.
Kerry Fink with Helping Seniors of Brevard, and what a pleasure it is to have you join us for Helping Seniors Television today. I have the privilege of sitting in for our president and founder, Joe Steckler, as we get to talk about helping develop your aging plan so you can make the best of your golden and senior years. And today in the studio with us, I'm so pleased to have to announce to you, we have Amy Van Fossen, who is one of the area's preeminent elder law attorneys and really has great information that will help us as we think about our own aging plans. I always like to start the show by saying a little bit about this. As we go through our growing up years, you know, the adults are always telling us, well, what is your plan when you get out of school? Are you going to go to college? Are you going to get vocational training? Are you going to join the armed forces? What is your plan? What is your career going to be? We hear that. So we're forced to think about, and probably rightly so, about what we should be doing as we move into our working years. And then as we're in our working years, all the experts say, well, you need to have your financial plan for retirement. You need to be thinking about whether you're going to send your kids to school, what you're going to do for them, what kind of house you're going to have, all those kind of decisions. So we have a plan as we're moving along. But then we get to our retirement years. The question is, do we have an aging plan, which is how we're going to manage the things that we're likely to run across as we get older. And so well too often, as I'm sure you can attest, we find we run up on emergencies. And so as we were talking about the title for today's show, Amy, we really wanted to cover this topic that you had mentioned in a recent seminar, and I thought it was fascinating. And you said, I will tell my clients, don't put your kids on the house title, don't put them on the bank account. And then you proceed to explain why. So I really thought this would be a great opportunity for us to talk about how to work this out the right way. So welcome to the show.
Well, thanks for having me again. There's a lot of different ideas, and a lot of times kids put, or beg mom or mom and dad just decide, sorry, to put kids' names on titles to houses or bank accounts, and there's better ways to do it. So if ultimately you're trying to avoid probate, there's better ways to do it, whether having a really good durable power of attorney in place, which would allow the kids to make legal and financial decisions for mom or dad, or a revocable trust or an irrevocable trust. So these are ways to transfer property after you pass away. And in fact, the power of attorney allows the kids to help manage it while they're alive. The worst thing to do, I believe, in my opinion, is putting kids' names on any of those assets, because there's multiple reasons why we don't. And part of it is because I see a lot of negative stuff in my office. I see a lot of fraud. I see a lot of elder fraud. And so just by example, I had mom and dad married 60 years. Dad passed away. Son flies down from up north, puts his name on mom's house because attorneys are bad. The state of Florida is going to steal your money. We want to avoid probate, all of these kinds of things. And so mom agrees. Mom puts son's name on her deed, signs the deed over to him with her jointly. He mortgages it to the hilts, refuses to make the mortgage payments. Mom is foreclosed on.
Oh, no.
So mom and dad's aging plan is completely blown up, and we had to find senior housing for mom.
Wow.
So she basically was out on the street. And so that was my first case where I got involved after the fact. I did not do the deed, thank goodness. So there's just multiple reasons why you never want to do that. As well as I had, again, same scenario, dad passes, son put his name on mom's deed, attorneys are bad, the state of Florida is going to steal your money, we're going to avoid probate, yada, yada. And son got divorced, and the house had to be sold to pay the ex-daughter-in-law 25% of the value of the house.
Wow.
And so there's all kinds of reasons that I've seen in my office that I will never, ever put a kid's name on a deed.
You know, one of the things we've done a lot through Helping Seniors, we do a lot of community information events, which you've spoken at several of them, but I was thinking about a recent event where we had actually the state attorney, Phil Archer, come in, and he was talking about senior frauds. And one of the things that for most of us is surprising when we don't have the overview like you see, is that more often than not, these frauds, the really bad frauds end up happening because somebody trusted a family member that they maybe shouldn't have trusted, or had somebody come into the home. It was somebody very close to them that had access, and then it became a problem. So I was thinking in particular about that scenario where even if mom or dad says, listen, I have the greatest son or daughter in the world, they would never do anything to harm me. I think your point that we have to think about is that it's not always up to that great son or daughter, because there could be other things that come in, just like you said, the divorce comes into play or things like that.
Exactly. And more and more, I think a lot of the senior fraud in Florida, I do believe, is a family member. And I see it often in my office. I jokingly say I don't trust your kids, but I've just seen too many negative things. And you can have the best kids ever, but you don't know, maybe they are sued.
Right.
You know, and it's outside of their control. They're still great kids, but something has happened, or their child, you know, gets into some type of trouble, and they need to look at the equity of the house. And so, especially if there's more than one child involved too. If ultimately mom or dad wants to leave all of their assets to all of their children equally, and you only put one child's name on all of these assets, mom or dad pass away, that child does not have to legally divvy that up with their siblings. And that's a big misconception as well, because I'll have women all the time, especially in their 80s, 90s, say, I'll just leave everything to my oldest son, he'll take care of his siblings. I will never do that. It never happens, because it could be a marital asset. So if you leave everything to your one child and they're supposed to divvy it up, there could be gift taxation going from that child to their siblings. If they are like a New York resident, it could be a marital asset. Sometimes inheritance are in different states.
Wow.
So there's all kinds of different things to look at. In our office, it's a policy just in my office. It could be in other offices. We will never do a deed adding a kid's name to a deed unless they are financially putting money into that property.
And you also said the same thing, because this was a great seminar that you gave, and you were talking specifically about protecting your nest egg and how to make sure that your money didn't run out. And it was more than the obvious things that you might think about, is like, how much do I have in savings? But you were actually talking about all these, what I would call safeguard measures that you were talking about. And you mentioned, like, people say, well, I'll put my son on the bank account so he can write checks. And you said, no, that's really not the right way to go about that.
No, I also don't agree with putting kids' names on the bank account. The way around that is a durable power of attorney. So the power of attorney allows your child, or maybe two kids acting together, to be able to write checks for you if you have a medical crisis. That's always the thing. Well, if I go to the hospital, who's going to pay my electric bill? So the kids will go to the bank with mom or dad. The tellers at the bank, or the girls at the bank who do new accounts, will say, oh, I'll just add your kid's name onto the bank account. They can write checks if there's an emergency, and then if you pass away, it avoids probate. Well, you've now cut out all of the other children. It's now open for liability. It's now the kids can steal all of the money as well. And so I don't agree with that either. Again, the power of attorney or a revocable trust, where the child can be a co-trustee to help mom or dad manage the money, is far cleaner and safer than just adding your name to the bank account. I fight with bankers all the time. I really do. And there's some banks that are more prevalent than others, but you know, I'll do a comprehensive estate plan, send my clients to the bank, and the bank lady will completely blow up the estate plan by saying, oh, just add your kid's name to the bank. You don't have to put it in the trust. I'm like, why did you pay me to do a trust if you're not, or an estate plan, and not follow, you know, our directions?
Well,
So
isn't one of the points that you're bringing up, which is important, is that maybe the person, mom or dad, has identified this is probably the right way for me to manage this, but what you're suggesting is, let me set this up the correct way that protects all the parties. So there's really, doesn't it really just keep everybody, I guess, on the right frame of mind when you set up all the safeguards in the right way? It puts limits. It probably, even if there was, you say, well, this is the son that I want to trust to be able to handle this, but he's getting pressure from siblings, but now the paperwork backs up everything that's moving along.
Exactly. I mean, and sometimes we do have one child with more time and more has more responsibility and can handle these things. It may not be your doctor's son who's a huge surgeon in Chicago. I mean, even though he's very intelligent and could do it, he doesn't have the time to actually take care of mom and dad. And maybe it's your daughter who's been a stay-at-home mom and who's very kind and caring. It might make more sense for her to be on the documents.
Sure.
So it doesn't mean the most educated is the ideal choice. We need to see who, and also who's going to be fair to their siblings. right? You want the one who you're going to trust to make the right decision for all of the kids.
And I think that is a point that I really got from your seminar on this topic, was that the very fact that you would sit down and get the expert information and help, which has to be almost by definition customized. You can't just in a seminar say, well, this is what you do, and that's why somebody really has to sit down with you with the right documents in their own particular situation, so you can help guide them correctly legally to set up a scenario that's going to be correct for them.
I think so. I mean, even on the medical document, I have two daughters. One's an attorney here in Brevard County. She practices in my firm, and I have a daughter who is a nurse in Oregon. So on my health care surrogate, obviously I want the nurse on it, but she's, hours away, and so I have both of my kids on it equally. So either one can make medical decisions for me. The power of attorney, I don't like the word or, so I have the attorney daughter first and the nurse second. And so it has to make sense. And every legal document, you can change who the people are, who the players are on each document. So if it makes more sense, you've got an accountant child, they would definitely be great trustees, great powers of attorney. You've got a daughter that's a nurse like I do, they'd be great on the medical one. So every family is different.
And that's why it's so important to figure that part out. Recently we did a television show with one of the attorneys in your law firm, and it was on the topic of guardianship. And it was really fascinating because he said, listen, when somebody comes into the office and they just found out mom or dad had a medical emergency and they didn't have all this paperwork set up, he said, now, they said, well, can't we just, no, we can't. Really, at this point, the only thing we can do is a guardianship, which is, there is a great show, by the way, and I want to encourage you to have a look. All of our TV shows, by the way, are archived on helpingseniors.brevard.org, helpingseniors.brevard.org, and you'll be able to link through to our YouTube channel. And there's more than 250 great television programs that Joe Steckler and myself have put together over the basically the decade of helping seniors. And you can go in and search by topic. But what he was saying was, in guardianship, he said, that's all that's left to me, even if you, son or daughter, is going to end up being the family guardian at that time. And so if we could rewind the film a little bit and get these things in place ahead of time, all that extra expense and all that extra headache wouldn't have to come into play if people would not. So it's like there's a middle road. You don't take to just write their name on the title, and you don't want to wait for the disaster on the other end. You want to take the prudent path, right?
Oh, absolutely. And some things make sense. And we make a lot more money by fixing things after the fact than being proactive. And so I love proactive. We have time. We can make good decisions. We can say, okay, if this happens, here's option A, option B, option C, and we can talk about all of the different things that could possibly happen. And it's legally a lot. I mean, financially, it's a lot cheaper on the legal side if we're being proactive and taking care of these things. You can avoid probate, you can avoid guardianship just by letting us doing some basic documents. They're not even that complicated, but not all documents are the same. Like Greg probably talked to you about our durable power of attorney. It's a document we've been creating for over 14 years. We keep adding to it because certain banks have different requirements, or Medicaid has different requirements, or the state of Florida changed the rules. And so, yes, you can go to Staples and pull one, but it may not fit whatever intricate things that you need.
Well, isn't that the other fact, too, is that we live in a state where they tell us that 900 families a day are moving into the state of Florida, because this is a place where everybody wants to come to. We have great weather. It's a low-tax state, and it's just, speaking for myself, I think it's a great place to live. But the problem is people come down here and they have all these documents that were prepared, someplace up north or out in the Midwest, and they come down here and then they find out that may or may not be appropriate for the situation based on the rules of Florida. That's another thing I wanted to ask you about, is because we get calls so often from somebody who's just settling into the area, and it would seem like it would be prudent at the very least that they sit down with an expert Florida attorney and say, well, here's what I got. Is this going to do what I think it is trying to do? Well,
and a lot of the documents are just fine from other states. So I get asked to do that all the time. We're all from back north for the most part. I'm from Ohio. The power of attorney is the only one that I won't even look at it. I'm going to redo the durable power of attorney. The state of Florida is so strict on the rules. They have these new things called superpowers.
Right.
Because I'm a Medicaid attorney, we have embedded lots of Medicaid type terminology in our durable power of attorney, which will not be in the one at Staples, right? Or the one, I had an engineer pull one offline and it didn't have Medicaid language.
Wow.
Mom didn't have capacity to sign a new one. We're in guardianship.
Wow.
But if you have a power of attorney written in another state, absolutely it has to be redone. If it was written prior to like 2011 in Florida, it has to be redone. But sometimes wills and trusts are okay. If you have a revocable trust in another state and you move to Florida and you want to homestead your house, I have to amend it to add for the homestead language.
Okay.
Because Florida homestead is a very big deal.
Yes.
It's one of the best benefits that we have as Florida residents is the homestead. And so that's a very often tweak I would do to a trust. So a lot of times their old stuff doesn't have to be completely redone. It just has to be amended a little bit, except the power of attorney absolutely is getting redone.
You know, the analogy that comes to mind from a non-legal standpoint is, you know, it's like when you have an emergency generator or you have an emergency backup battery, but if you didn't have it prepared for when the lights go out, it may not do what everything that you'd hoped it had. And it seems so important to take the time to get this kind of stuff right. And so again, if we take shortcuts like putting the kid's name on the house or something like that, the other thing that I understood from the presentation that you gave was there's oftentimes a lot of unintended consequences. The mom says, well, I'm going to give this money to Jimmy anyway, so let me just start giving it to him. But then we find ourselves in a Medicaid situation, and now with look-back periods and all this, what was done with the best of intentions is now going to create a problem.
And it could cost thousands and thousands of dollars. Medicaid is a 5-year look back. So if you add a kid's name to a bank account within 5 years of you needing Medicaid, it's technically a gift. And generally, some gifts we can fix, some things we can't. What happens often is someone passes away. Let's see, dad passes away, mom needs to go into a facility, son flies down, puts his name on everything, hires me, and then I make them go back to the bank and take their name right back off, you know? So that's a consequence, as well as back to the homestead thing. If you add a non-Florida resident onto a deed, mom could lose her homestead exemption. A house is exempted on Medicaid, it's an exempt asset. And so again, adding, let's say, a New York resident to a Florida deed, if mom loses that homestead exemption, the house could be up for grabs in the Medicaid process.
Isn't that why, again, everything you're saying just reiterates the wisdom of taking a few minutes to sit down and figure this out and have somebody that really knows what they're doing have a look at it so that we can make correct decisions, not by the seat of our pants. I know you're one of the county's leading experts on VA aid and attendance, and that also has now shifted where there is a look-back period. So all this becomes even more, and just, you know, I was saying to somebody earlier today, we live in the county of NASA, so everything has an acronym, and just like we don't necessarily understand all the acronyms that they use when they launch the rockets here, a lot of times as consumers, we don't necessarily understand all the lingo that's important. So when we say look back period, I don't want to just say that and assume that we all understand what it is. Maybe if you explain to us just an overview of what that means and why it's important that we have to factor that in.
Well, look back period for Medicaid is a 5-year look back that says that if you gave all of your money away and you need Medicaid within a 5-year period, you will be penalized. So you cannot just give all of your money away and say, okay, now I'm going to put mom in assisted living or skilled nursing the next day and the state of Florida is going to pay. So literally there's a snapshot date. So you apply on January 1st of 2020, they're going to go back 5 years prior to that and look at every bank statement, every transfer for the most part, as well as the deeding. You know, if we've added names to deeds and things like that. And so they have the right to look at all of the transactions. Excuse me. VA does a 3-year look back now, and it's such a huge penalty on the VA side that it's very difficult to do any transfers on the VA side now. The amount of money that you can have for VA is significantly higher than on Medicaid, though. So when we have someone coming in, we have to look at, were there any gifts? What penalties are we looking at? Do we just get beat up on the gifts and let the time toll and apply later? Does the kid still have the money? Oftentimes the kids have to give the money back to mom and dad. Then we do our Medicaid planning, and then there's legal ways to possibly give the money back to the kids in the form maybe a care contract or something like that. So I had a daughter take $100,000 from mom, pay off her house. She had to remortgage the house, give the money back.
Oh,
and
wow.
then a month later we gave it back to the daughter
Wow.
and she paid off the mortgage, but that's
Wow.
thousands of dollars in fees
Right.
at the mortgage company.
Wow.
But mom was looking at, 8 to 10 grand a month in skilled nursing expense for a long time. She was relatively healthy, but had to be in skilled nursing.
Yeah, see, isn't that the point too? Is like, so what is the penalty if you get stuck in this look back period? And as I understand it, and correct me, I mean, tell it straight because I'll probably bungle it. But isn't it have to do with the amount of money before they would help you with the cost of that facility?
Medicaid, the divisor's about $8,000-ish. So let's
Wow.
pretend you give away $80,000, you'd be penalized for 10 months of Medicaid.
So that means that first 10 months, and if you have to be there, you are flat on your own then.
Which means someone's paying the tab.
Wow.
Right, Medicaid, or the VA, sorry, divisor's about $2,300, I think, a month. So it's a much smaller divisor.
Okay. So again, with all this complexity, you can't just say, oh, here, I'm just going to put my son's name on all this and assume that's the fix. Because I think if, viewer, if you've had any opportunity to think through some of the things that Amy has been talking about, you're going to get a real clear sense that, just a slight jog left could cause all these unintended consequences that you just don't even want to think about. And if you spent your entire lifetime putting things together in such a way that you want to benefit the people that you care about, it really makes sense to try to sit down and figure this stuff out ahead of time. What would you say to somebody that maybe piqued with curiosity, so like, wow, I don't know if I did this right. I may have already done some of this wrong. Should they mea culpa and come to you and say?
Yeah, the quicker the better. The sooner we can fix it. Every attorney's going to do an analysis of the assets, basically. So we need to say, where is the money? What type of assets do you have? Has there been gifting? A lot of people say there haven't been gifting, and we look at the bank statements and we're like, oh my goodness, there's so much stuff going on here we have to fix. Again, some things are fixable. It's not the end of the world, but not everything is fixable. I like to do the analysis first, that's where we spend just a ton of time looking at, is it an IRA or not an IRA? Did you give $50 away for Christmas to grandkids, or was it $500? Because 50 is okay and 500 may be way too much. Right? And so you have to look at all of those things.
It is really complex. But then I guess the comforting part about it is that when you take the time to do this, it sounds to me like you have a lot of tools that legally and correctly you are able to bring to bear to accomplish what the person wants to get done for their family. They just need to go about it the right way.
I always say, okay, we're at point A and you want to get to point B. I just have to figure out how to do that. And I always say we're not the judgment zone. I don't care what you want to do with your money. It's my job is for it to be distributed however you want it to be distributed. And before being an attorney, I was a Series 7 stockbroker. So I like to look at the investments. Are there back-end sales charges? How are things titled again? How are things held? Are there a whole bunch of annuities, or are they IRAs and different benefits? Like Medicaid is kind of okay with an IRA. VA's not. And so you have to look at all those types of things. I also have quite a bit of tax in my background. So you have to look at the taxation.
Right.
If we start liquidating this stuff and pay a kid a care contract, what type of taxation for mom and the child getting the money? And so you can't just kind of look at this in a bubble. Oh, I'm just going to give my house away to my kids or give the bank accounts to the kids.
Right.
We have to look at all of these things. So whether it's back-end sales charges, taxation, are there stepped up cost bases if we wait for an asset transfer after death? That's another reason why I don't like names on deeds to things like that, because if you pass away, you bought a house in Indian Atlantic for 50 grand and you pass away and it's worth $500,000, the kids don't pay capital gains tax if they get it at death.
Right.
If you put the name on it during their life, your life, there's going to be some taxes paid.
And here again, what I remember too that you guys were talking about recently was with some of the recent tax law changes too, the idea of handing over a pre-tax IRA could be handled completely different now going forward because of the distribution rules having been changed. So here again, everything that we talk about, and I think I remember you guys sort of halfway joking about this comment that, oftentimes somebody gets an off the software kind of solution and thinks they're going to put something together, and that really creates a lot of business for you when you try to have to go back and fix what they thought they were going to get done for $39.95.
Oh, absolutely. I mean, if you don't do the power of attorney correctly, we've seen it in our office where often you think you have a power of attorney taking care of everything for mom or dad lose capacity, you actually try to use the document and it's not usable. And the only alternative then is guardianship. So your $39 power of attorney is going to cost you thousands of dollars in guardianship.
You need to really be careful about that. So one of the things that I want to say to you, viewer, is if you will check, Amy is really good about doing series of seminars throughout the county at various points where you're basically preaching this story about let's get you set up the right way. What's a good place? Is there a website or something that, or what's a way that people can find out about these seminars, which might be a good way to just continue to expand their knowledge about these topics?
AmyBVanFossen.com.
Okay.
We should have a list of our seminars. Excuse me, or you can call our office. Every month we do a seminar on estate planning, which we're doing next week, VA, and Medicaid usually. The estate planning ones are more popular than I ever thought, so those usually get booked pretty big. But you know, all the time we're constantly talking. I'm doing a VA one I think at the end of this week in our office.
Okay.
So usually 2 or 3 a month in our office, and then 2 or 3 out.
All right. And if they're going to call your office, what phone number?
321-345-5945.
One more time.
I talk too fast. 321-345-5945.
Usually if I'm doing this right, I say, folks, grab a pencil. So I'm going to give you a moment to grab a pencil, and then I'm going to give you the Helping Seniors number, which you can call us, and we'll make sure you get in touch with Amy's office and find out about the schedule for these upcoming events. So our number is 321-473-7770, 321-473-7770. Well, that's the time we have. Thanks for joining us today on Helping Seniors TV.
Thank you.
Joe Stackler, thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses, and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we would welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.